So I'd like to introduce Paul Wentworth. He used to be the head of law school. He also presented the Law Society's case to the Select Committee regarding the Marriage Equality Bill. He's got extensive he has extensive experience with human rights and international law, and he's going to give us a talk on that, how that interacts with the Marriage Equality Bill. So I'd like to thank Paul for coming in. And if you've got any questions, just chuck your hand up and we'll take them as we go.
Yeah, so first of all, thank you very much for the invitation. And I thought I'd start by saying what an auspicious evening this is, because tomorrow is the 27th of March, and it's the day that the New Zealand Parliament considers the committee report on the same-sex marriage bill. And then I understand that in perhaps 2 weeks' time the third reading would occur. And so we've got tomorrow with quite a momentous day in our Parliament. Also tomorrow, although Tuesday the 26th in the US, but Wednesday here, is the US Supreme Court beginning to sit for the first of two cases on the same-sex marriage issue in the US. And I have something to say about these two cases a bit later on, but I just thought it was interesting to see that sort of juxtaposition, that one country we've got Parliament debating same-sex marriage, in this other country in the US we've got it before the courts. And that interests me because the talk that I wanted to give tonight was really about the sort of architecture of international human rights law and how it plays out in our own legal system, and how it sort of allocates the decision on controversial issues, whether it's to parliaments and the people's representatives, or whether it's to courts, and what the interplay is between those two institutions, the courts and Parliament. So that's essentially what I'm hoping to do tonight. And as Josh mentioned, I'm also the convener of the New Zealand Law Society's committee that does submissions on law reform issues. In that capacity, put together the Law Society submission on the same-sex marriage bill, of which I'll have something to say a bit later on. So please feel free to interrupt at any time and ask questions. Don't save them until the end.
Speak loudly.
Welcome. So I couldn't fit the whole title in, but what I wanted to do was look at how international law relates to New Zealand's law, which I call domestic law. And I want to look at how this plays out in the specific context of A, the case for same-sex marriage on the one hand, and then the case for, if you're going to have it, religious exemptions for marriage celebrants who are called upon to perform same-sex marriages. So there are those two aspects of it, the case for, and if for, then exemptions. So I'm beginning by going back in history with international law to its very beginnings. And international law, as you may know, is the law between nations. And because there's nothing above, or historically has been nothing above nations, then there's nobody that lays down international law. It's something that evolved through custom and convention and practice between nations. And it goes back to medieval times, but particularly flourished and blossomed during the period of the discovery of the New World, when the question was, how do territories acquire new territories? And what are the rules about how one nation can say it has dominion over some other area of the globe? So the international law began as the law between nations to solve the sort of controversies that nations have. And they would be about acquisition of new territories, about warfare, maybe about diplomatic representation and the access of consuls to other states and safe transit and so on and so forth. But what international law was not concerned with was the rights of citizens within states. And going back to the New World, it's interesting just to reflect how we see this played out in our own history, that as a matter of international law, custom or convention that prevailed between the European powers, they sorted out rules to decide which of them had dominion over the United States, or the territory we now know as the US, or South America, was all about the European powers and their entitlement to be the ones that would then go and deal with the Indian inhabitants. International law was not concerned with giving rights to the Indian inhabitants. It was concerned with which of the European powers had the responsibility for that area. And so they began the sort of devices of sort of landing upon beaches and burying the claims of a European power and planting the flag. All of these being symbolic acts to invoke consciously what international law was saying, that yes, you can be the sovereign over a new territory if you discover it and you occupy it effectively, or if you make a treaty with the people there. But to make a treaty with the people there needed to be a sovereign power that could also make treaties with you. And therein lay a sort of story over how international law dealt with that particular question, because, and you see it played out in Australia, no treaty made with the Australian Aborigines that was said by the English to be occupied and settled, as if there was nobody there. And they're still dealing with the implications of that. We in New Zealand will see that when the decision was made in England, as you know, to acquire sovereignty over New Zealand, the method chosen was to seek a treaty with the indigenous people of New Zealand. And we're still reckoning with the implications of that. But the point is that these are nations invoking the categories of international law about how new territories are acquired. And that was one of the main sort of subject areas of international law. There are incidental references to the rights of Indians, and what I've got on my next slide, I believe, is a picture of Bartolomeo de las Casas, who was a famous Spanish theologian who very strongly articulated the rights of Indian people, Indian meaning what we might now call First Nations people, or the American native peoples. And so international law, in that sense, had advocates for the rights of people within nations. And particularly what Bartolomeo de las Casas was arguing for was that the colonising powers must respect the rights of the native occupants. And it's interesting we see this played out in contemporary US law, because contemporary US law still regards the Indian tribes as what they call domestic, dependent nations. And technically in American law, their sovereignty of the Indian tribes has never been taken away. They can still regulate their own internal affairs. All that happened when the European powers went there was that the European powers became the ones that could say, in relation to other European powers, this is English, or this is French, or this is Dutch. And how they then dealt with the indigenous people was a matter for that power and that power alone. And in the US, the remnants of the theory is that the Indian tribes are still sovereign nations, but now domestic and dependent. And the one thing they can't do is have international affairs with other sovereign nations. Anyway, that's too much detail about American law. I'll press on to the 20th century. In the 20th century, international law began to be concerned with the rights of people in countries rather than the rights between countries. And it began with international labour conventions concerned with the rights of workers. Then the rise of humanitarian law, or the laws of war and how prisoners could be treated. And then in World War II, where the expression never again and the expression human rights emerged. As the atrocities of the Nazis became known to the Western world, the expression human rights came to be used for the first time. I mean, there'd be the Declaration of the Rights of Man back in France in 1789, and there was certainly a Bill of Rights in the US and in England, but the idea of human rights, and that particular phrase, it goes back to this period. And so in the immediate aftermath of the Second World War, as you will know, was the formation of the United Nations, and its first major mission was to draft the Universal Declaration of Human Rights. And this is the sort of foundation of the modern human rights movement, because for the first time a country's domestic affairs became a concern of the international community. And they needed to have a drafting process. And so a committee was set up comprising Mrs. Eleanor Roosevelt and some others. And I just go through these people who were the main people because it's sort of an answer to the idea that human rights are a sort of Western construct and sort of not really reflecting the views of the world. Charles Malik was from Lebanon, Rene Cassin was French, P.C. Chang was from China, and there were others. And this committee was charged with the task of drafting a declaration of human rights. At the same time, there was another committee charged with drafting a binding convention on human rights, and I'll say more about that in a moment, but suffice to say that was to take another 20-odd years. But the declaration itself came more quickly. And my third point on this slide is, I think, significant. That in order to decide what to put in the Universal Declaration of Human Rights, the committee did its work, as you might expect, by what I call reverse engineering the principles that are found in the world's major legal systems. So if you were to ask a person in the English or the American, the sort of common law world as it's called, which are all in the same tradition, what are our basic human rights? You'd come up with a list that said something like life and freedom to live and move where you think fit, liberty, expression, religion and belief, and not to be tried in an unfair way. You'd come up with that sort of list. And then you could say, we find these principles reflected in all the details of our legal system. So when it comes to the right to a fair trial, that is manifested in probably 100 pages of small print about jury trials and the right to a lawyer and the right to legal aid. But if you abstract that, what's it all about? Fairness. And so the drafters were saying, when you look at the legal systems of the world and abstract the underlying principles, what are they? And they turn out to be much the same, as you would expect, because the concerns of humans are pretty much the same across the world's major legal systems. And so it was that the text of the Universal Declaration was agreed. And there were certainly controversies. And there's a great book about the process from which you can see how irritated they all were with each other. And this was taking place against the backdrop of the Cold War and the separation of the East behind the Soviet bloc and the Free West. So there were great tensions happening, and these had played out in the UN committees. And there's Malik from Lebanon and Rene Cassin and Mrs. Roosevelt. And there's a picture of P.C. Chang, what turns out to be possibly a rare moment of getting on pretty well with Mrs. Roosevelt, according to the book. And I just put that in because I found that sort of interesting. It's the Russian representative, Mr. Pavlov. So that was the time when the Universal Declaration was put together. So from that, I just wanted to highlight a few particular issues. One is that rights aren't an invention of international law. They exist in societies around the world, even if they're not reduced to lists. But in 1948, and in the lead-up in the drafting process, that was the time when they were abstracted as principles to put into a document. When abstracted, they become fairly vague generalities like free speech and equality. And forever after, it becomes a question then of working out, well, what does that mean in a particular context? Next point, Universal Declaration is, as its name tells you, a declaration only. It's the United Nations saying, here is a declaration of the world's human rights. It was not intended to be a binding instrument. It wasn't intended to give remedies to anybody. It was simply a declaration. And the same thing has happened more recently with a declaration on the rights of indigenous peoples. And it's quite common in the UN system for there to be a declaration before there is a binding covenant on a particular area of human rights. Just what a binding covenant actually means in practice needs to be looked at as well, and I come to that in a moment. So right from the start, a binding covenant was envisaged, but this became tricky in the light of the Cold War that was developing immediately after World War II, and what was to transpire. And the committee charged with drafting a binding covenant on human rights found that its work took until 1966, and in the end they chose to separate out two types of human rights. The UDHR, the Declaration, to put them all together. The two covenants separated them out. On the one hand were the civil and political rights, which were the right to vote, free speech, religion, fair trials, equality. On the other hand were the economic, social and cultural rights, which were things like the right to health care, the right to an education, the right to welfare, and so on. And the reason for the division over that was that the Soviet Union and the Soviet bloc were saying, well, the economic, social and cultural rights are our thing. You know, we're guaranteeing everybody houses and jobs. And don't come at us with the civil and political rights. And the West was saying, it's the civil and political rights that really matter. People must be free to think and believe and to argue against governments and to have freedom of religion and so on and so forth. And when you have those in place, then the ordinary democratic system will produce economic and social and cultural rights. And therein lay the sort of great sort of rift between East and West. And that explains why there are these two binding covenants, ICCPR and the ICESCA, as it's commonly called. So we only need to think now about the ICCPR. And what is it? It's a catalogue of civil and political rights, speech and religion, fair trials, and equality. How is the ICCPR enforced? Well, to understand the way it's enforced, you need to understand that it's enforced through a Human Rights Committee. And the Human Rights Committee is technically called a treaty body, meaning it's something that the treaty itself creates, as well as saying everyone has freedom of expression, freedom of religion, fair trial rights, and so on. At the end of the ICCPR, it says there shall be a Human Rights Committee, and it shall have the task of interpreting this treaty. And it carries on with some periodic reporting requirements that every state that elects to become a member and signs on to the ICCPR is thereby committing itself to an obligation of periodic reporting. And we see this in the newspapers, you know, every 4 years in New Zealand. You will see little write-ups about the presentation of New Zealand's report to the Human Rights Committee, and what these reports consist of is quite a lengthy document in which the Ministry of Foreign Affairs will orchestrate the putting together of this. They'll send it out for consultation, and it will go through the various provisions in the ICCPR, you know, the right to life, the right to freedom of religion, the right to fair trials, and it will set out underneath all of those all the various ways in which our law strives to give effect to the right to life. And for the right to life, just to take one example, you know, it would be common for a state to say, well, here's how we affirm the right to life. Not that we simply don't go around killing people, because that's the most obvious way that the state would protect our right to life. It's more than that. It's that we have an adequate criminal law, an adequate police force to make sure that citizens don't kill each other. We have coroner's inquests to explain the unexplained death, because, you know, if we don't have coroner's inquests, then life becomes cheap. And we have child health measures and inoculation. We have hospitals. And so you can see how you just take the right to life and you start thinking about it in a positive way and saying, what must a state have in order to protect its citizens' life? You can build a lot of what actually happens in our legal system and our administrative system, hospitals, inquests. So you can see that these obligations, so they're highly abstracted, you know, a right to life, in fact are the foundation for a host of detailed laws. Take, for example, the criminal law about self-defense. When is it okay to kill somebody? Answer, when you are defending your own life or the life of another person. And the point about a right to life set out in a document like this is it becomes a sort of standard to measure your criminal law and your other law against. Do we in this country respect a right to life? Generally, yes, because our law values life, and it's the way it is because we value life. But you can imagine how you can go a little bit wrong with law. Like, what if our statutes said that a policeman can shoot to kill a fleeing suspect? And you think, well, that might be okay depending upon the circumstances, but who in our right minds would think that if you are wanted for, say, non-payment of fines and you run away, that you can be sort of shot in the back? And if our law purported to justify the killing of a fleeing prisoner, then it would not comport with this value of human life. And that's sort of inquiry that a Human Rights Committee or courts, as we'll come to, when they get the chance to evaluate law, might make. And so, in a sense, this international law becomes a standard against which you must measure the detail of your local law or your domestic law. So anyway, the first point that I wanted to make is that the reporting obligations, every country must go to the Human Rights Committee, which sits in Geneva, and typically a minister of Justice or Foreign Affairs will go, accompanied with people from the ministry, and present the report. The committee will ask questions. Typically it will ask about, say, Maori overrepresentation in prisons or in health statistics, and it will say, what are you doing about this? And that's the way in which the Human Rights Committee monitors our progress against the ICCPR. The other way is that there is the optional protocol, and its name gives it away, it's optional. A country that accepts the obligations of the ICCPR doesn't have to accept the protocol, but New Zealand has. And if you do, then what you are accepting is the right of a citizen or indeed a resident of New Zealand to take a claim to that same Human Rights Committee and say, in my case, New Zealand has violated a right it's promised in the ICCPR, in my case. So you can see the ICCPR is like a promise that the state of New Zealand makes to the world, saying we too are joining in this covenant in which we agree that these are the rights of our citizens. And we will make sure we maintain a legal system that gives effect to all those rights. And the optional protocol would enable a citizen who's been through our law and then says at the end of it, hey, I got convicted, or this happened to me, but the covenant says it shouldn't happen. Now, I applied for a marriage license to my same-sex partner. I didn't get it. I contested a case through all the courts of New Zealand and I still lost. And yet I say the ICCPR requires that I be able to have a same-sex marriage. That would be the situation when you take a case under the optional protocol to the Human Rights Committee. And there was such a case, which I'll talk about a little bit later. When the Human Rights Committee gets complaints like that, it will then give its views, and they're called views, and they chose the word views rather than the word judgment to emphasise that they're not really a court, they are giving an opinion. They think this shouldn't happen. It's still for the state to decide what to do about the views. They're not binding. There have in fact been 21, not 20, I just checked before I came, 21 cases to date since New Zealand adopted the optional protocol, which was in 1989. So it's not a major forum of litigation. Very few lawyers would know about the optional protocol procedure. And I guess that would be because there's no guarantee of any remedy. All you get is the views of the committee. But nonetheless, there are some cases of interest, and a couple of them are the major cases. There was the Maori fisheries settlement back in 1992. Some of you might remember that. It was called the Sea Lords deal at the time, when there was a lot of litigation by Maori over whether or not the offshore commercial fisheries resource could be sort of privatised and propertyised and leased and sold to commercial organisations. And it was rather like what's happening now with the hydroelectric dams and the mixed ownership model, asset sales. And so back then, There was a big settlement with Maori, but those Maori who didn't agree with the settlement took their case off to the optional protocol procedure and the Human Rights Committee, saying that the Sea Lord deal breached their right to culture. That was the phrase in the ICCPR, that minority cultures have a right to their culture. And they didn't win. The Human Rights Committee said, well, you were consulted with. Most Maori accepted that it was a good deal. The Waitangi Tribunal thought it was a good deal. And so, look, it's not that bad. And so they, in other words, they appealed to an outside source, the dissenting Maori tribes, said, we haven't won our case in the New Zealand courts, let's go to the Human Rights Committee. But the Human Rights Committee wasn't persuaded. Jostling was a case, and I'll come back to that because it fits better later on when I get to talk about same-sex marriage particularly. But there have been quite a few other cases in the fields of criminal law, mental health law, and pensions. And the pension case is just about UK migrants and some sort of alleged discrimination in the way the tax system treats their pension. You know, so it's not major litigation, except to the people involved, I'm sure. So there's a bit about the ISESCA. It's the rights to health, education, social security. How is it enforced? Well, it's got the reporting obligations, but not the optional protocol procedure. And I guess that's because that the nations of the world were not sort of rushing to have a committee that would second-guess their decisions about the allocation of resources in health, education, and welfare. I mean, if that was to happen, they'd be start asking questions like, who are these people on this committee anyway? And you know, what gives them the right to sort of say whether we're doing a good job in health, education, or welfare? And it's an interesting sort of question about the UN human rights system, that the Human Rights Committee, this is going back to the ICCPR, consists of 18 people. And there's never been a New Zealander upon it. And if you ask who are they, and you can go and find out by looking on the internet, and they're elected by the UN General Assembly, they're put up by their nations, and they tend to be retired judges or often legal academics. But they don't have to be lawyers, and that's probably a good thing. And so you can sort of see and you get the profiles and biographies of them. So I encourage you to do that, just to see who's on the Human Rights Committee. Right. The UN human rights system then entered into a period of what I call greater rights specification. The ICCPR was sort of like human rights for all. But then there was the CERD. In fact, the CERD came slightly before. That's the Convention for the Elimination of Racial Discrimination. And there was such a consensus around that convention that it was easier to arrive at agreement. And that came before the ICCPR. And that was the convention that says that states shall not discriminate against people on the grounds of their race, national origin, ethnic origin, and so on. And it's that convention that New Zealand adopted right back in 1972, pretty much the first available time for adopting it. And that explains why we enacted the Race Relations Act of 1971, which for the first time outlawed race discrimination in New Zealand. And we had to pass that law in 1971 so as to make it unlawful to discriminate on the grounds of race, and that enabled us to then adopt the Convention Against Racial Discrimination, because once we adopted that, we were promising the world that we would deliver to our citizens a legal system in which it was unlawful to discriminate against people on the grounds of race. So do you see a sort of pattern there, which is that because we've promised internationally that people have these rights, we need to make sure that our own law delivers these rights. And it turns out that our ancient law, the common law, didn't ever contain a right against being discriminated against, because its sort of fundamental principle is one of liberty. People can run their lives as they see fit. They can make their own contracts, they can let their houses to who they like, you can invite people you like to dinner, and you don't have to invite the people you don't like. You don't need to give a reason. And I think we'd all think that's probably a good thing in our own homes, But if you opened a shop, the old regime was you could apply the same principles to who you let into your shop. You could turn people away without giving a reason. There was no sort of right of access. What the Race Relations Act did is to say it is unlawful to deny access to goods and services or to rental accommodation or to employment by reason of a person's race. Then there was the Convention Against Torture that came in the 80s, and that was sort of like a greater specification of what is already a right in the ICCPR, the right to be free from cruel and unusual punishment and treatment and torture. Then there was the CEDAW, the Convention for the Elimination of Discrimination Against Women. Convention on the Rights of the Child is next. Disabilities Convention, and there's a Migrant Workers Convention. And New Zealand has adopted most of these conventions, not the migrant workers one, saying that it's not an issue in this country, not in the way it is in, say, Saudi Arabia, and where there's sort of great movements of peoples for work. So that's the UN system. So that's the essential nature of all of these treaties. They create a treaty body. It's a body to whom the reports are made, and if there's an optional protocol, to whom you can make complaints. And the committees can also make general comments, by which is meant they can establish a body of their statements about what the treaty means. And that becomes sort of like a jurisprudence that people can appeal to. So they can take their optional protocol cases and say, I claim I've been discriminated against, or I claim my freedom of expression has been breached. And to assist their case, they will point to the committee's own general comments about what the committee says the rights mean. So that committee can build up a sort of body of understandings about its the treaty that it is in charge of. The European Convention on Human Rights now needs to enter the picture. This is part of the same process, because after all, Europe was the theatre of the war. That sort of began it all. And the European Convention came much more quickly, I guess because they weren't mucking around after the Second World War and what it had caused there. And although it took the world a long time to agree the two covenants, the ICCPR and the ISESCA, by 1950 the European Convention had been agreed. It's a matter of historical record that the UK drafters were very influential in the text of the European Convention, which was to be a sort of irony even now, because the UK is not greatly enamoured of the European Convention. And it goes to make the point that human rights back then were very much seen as things for export. You know, we're fine if we can just take the principles of our legal system and put them into documents for the rest of the world. We're exporting our standards, but they weren't expecting the standards to be then sort of quoted back at them and for their own system to be found wanting. The European Convention has the set of rights which are essentially similar to those in the ICCPR, because they're coming from the same period and based on the Universal Declaration of Human Rights. There are differences, but many of them are very similar. And that has a different enforcement mechanism. It's enforced through a body which is called a court, and which delivers judgments which are reasoned in a way that lawyers are familiar with. Their judgments are much sort of lengthier and sort of less conclusory than some of the Human Rights Committee views. And so the European Court of Human Rights sits in Strasbourg, and Strasbourg is often used as sort of shorthand for the court. And so in the UK, it would be common for lawyers to talk about taking their case to Strasbourg, meaning that if you don't win in the UK courts, your final port of call is to go to Strasbourg and get them to say that UK law is defective because it doesn't guarantee properly the rights of a citizen as promised by the UK in the ECHR. Now, I'm moving from international law down to domestic law just to see how the two fit together. And we're looking at New Zealand's domestic law, which is the common law system inherited from England. And historically, rights were a basic assumption in the law, but not written down in lists. And that if most times over the last 100 years you were to ask a lawyer or a political scientist, do people have free speech? The answer would be yes, of course, because you're born free and you can say what you like. You can move where you like and associate with whoever you like. And we just have a basic liberty. And the only question is there any law that stops you doing something? And the lawyers for generations in the English tradition have said, that is our guarantee of liberty. That we don't need a law to tell us we can do things. We don't need a law to tell us we've got rights. If the law gave us rights, maybe it could take them away, and that would be bad. We don't look to the law to give us rights, we simply have them as human beings. And the full scope of our rights is measured by how much the law takes these rights away. And if you ask a lawyer, especially 50 years ago, and say, okay, well, what's the protection then against Parliament taking away our rights? They would say, well, it's the ballot box, that people who get elected and then start doing that will lose their seats in Parliament. And so it was the idea of elections as our protection against abuse. And the very first use of the word Bill of Rights goes back to 1689. And if you look at that document, it's very unlike what we now think of as a Bill of Rights. The whole point of that 1689 Bill of Rights in England, which was a sort of protest against the Stuart kings and an affirmation of the power of Parliament, the whole point was to elevate Parliament above the king. It was not, in fact, to limit Parliament. It was people saying, to get our rights, our Bill of Rights is to say that Parliament has a greater power than the king. Just skip forward a couple of 100 years, and now people might say parliaments are in fact the threat to our rights. But back then, parliaments were the guarantee of rights. So it was not the English tradition to put our rights into lists, except sometimes, for special reasons. And it was done in Magna Carta in 1297, as you probably know, when the sort of important people in the realm were fed up with the rapacious levies of King John and all the sort of regulations imposed and the obligations, and they wrote down a list of what they regarded as their rights. And it's interesting that even back then they were saying, these are our rights, from old. You never gave them to us, they are our rights. And we are saying that you must agree to them. And King John did sign, repudiated it a couple of years later. But one of the interesting things is there's a couple of clauses of Magna Carta that are still part of our law. And one is that it says, to no man will we delay or deny justice or right. It's often quoted in court cases. It's sort of been over or superseded by a lot of more detailed laws that have the same effect. But it's a great rhetorical device in an important case to quote Magna Carta. Of course, back then, the sort of justice that they were talking about was being hanged, drawn and quartered, and it wasn't exactly the sort of society that we would want to live in now. So I guess the point there is words change their meaning, which is interesting when we get to the word marriage. In the Bill of Rights, 1688, I sort of mentioned that. There was a list of rights, although it turns out when you look at the list, it's essentially a list of the rights for Parliament. Because what's the very first clause of the Bill of Rights, 1688? Which says, the King shall not purport to suspend the law. And the second clause is, the King shall not purport to dispense with the law. There's a bit of a distinction between suspending it or dispensing with it. So it's a statement of saying the law is above the King. And that was what protected people's rights. When it got to the US Bill of Rights, now they're actually writing down a list of things. But even then it's interesting to see the wording. The first phrase of the US Bill of Rights, does anybody know what it says? I think that's the Declaration of Independence. Yeah. And we the people is the first phrase of the Constitution. The Bill of Rights is the first 10 amendments, and the first words of that are, Congress shall make no law respecting an establishment of religion, nor abridging the free exercise thereof. And that tells you that they were really interested in religion back then. They were saying, we're making a constitution that creates a new federal government above us. But then when it comes to the Bill of Rights, the first thing they say is, here's something it can't do: establish religion, nor abridge our freedom of religion, nor abridge our free speech, nor abridge our right to protest, nor authorise unreasonable searches and seizures. So the idea of a Bill of Rights back then was very much put in the negative. Here's the things that can't be done to us. But Americans understand that now, rightly, in the positive way. We've got a right to freedom of religion and a right to free speech. Why? Because Congress has no power to take away our free speech and our religion. That's what the sort of right is, an immunity from laws. And that's an important aspect about the way human rights law works. So I started that with and, so I have to go back and see why historically rights were a basic assumption, except sometimes they were listed in Magna Carta and the US Bill of Rights. And, that's right, yeah. And they're also listed in many, if not most, post-World War II constitutions. Remember I said the UK thought rights were for export? They're sort of okay. But when they granted independence to Kenya, Nigeria, and even when New Zealand grants independence from the mandate it had in relation to Western Samoa, they were very careful to put bills of rights into their constitutions to say, well, you're on your own now with your own legislature, your own parliament, and here's the list of things you can't do: free speech, religion, etc., etc. So it became common for constitutions to have rights in them, and it's pretty much the standard around the world. And now even the UK has sort of jumped into the other camp. It has put into its own law the European Convention on Human Rights, which had been something in the international sphere, where, as I said before, a citizen could go through the UK courts and lose and say, hey, I shouldn't have lost, this breaches my rights, and then take the UK before the Strasbourg court. But one thing they couldn't do is actually bring the European Convention on Human Rights into the UK's own courts. Why? Because the European Convention is the law between states. It's the UK promising France and Germany and Lithuania and what have you, that it will guarantee these rights to its citizens. But that guarantee is not actually a part of UK law. And it's probably a good thing too in this sense, because in the UK only Parliament can make the law, and the European Convention isn't made by Parliament, and so therefore it's not the law. But in 1998, the UK Parliament said, OK, we'll take all the text of the European Convention and put it into our law so that citizens can appeal to it in their court cases within our system, and not just take our system to the European Court after they've lost. So the point of all that is the UK is sort of joined with the rest of the world with putting rights into its own law. So this sort of sums it up. International law is not directly applicable within New Zealand's legal system because it's international, the law between states. Even when that law is a treaty made between states in which New Zealand promises how it will treat its own people, even then it's still actually an international document. It's not a part of our law. To make it a part of our law, Parliament needs to enact the rights in the ICCPR. So the ICCPR can become a reason why certain laws should be enacted or not enacted. It can be a reason why, back in 1977, we enacted the Human Rights Act, just like we enacted the Race Relations Act to make race discrimination unlawful. Come 1977, why was it done then? Because in 1978, we ratified the ICCPR, by which we promised that no one would suffer discrimination on the grounds of sex, marital status, and a few other things. And our law couldn't deliver that without a special law being passed, and that was the Human Rights Act. So I think I've been through that sort of list before: life, voting rights, freedom of expression, religion, rights against some forms of discrimination, and liberty rights, e.g. the right to marry and to found a family. That's in the ICCPR. How does New Zealand implement it? Well, we ratified the ICCPR in '78. Back then, it's apparent that our advisors in the Ministry of Foreign Affairs must have believed New Zealand law to be basically consistent with what the treaty was going to guarantee. And so the only change made to our law was the Human Rights Act, which gave rights against discrimination, and it also included the criminal offence of inciting racial hatred. And you can see why that's in the ICCPR, because that speaks to the World War II and the very events that sort of began the whole process. Of course, in New Zealand, the modern counterpart of that gets sort of wheeled out for all the talkback radio hosts, and but its actual pedigree is it's designed to be the law that is the safeguard for the inculcation of racial hatred and prejudice that was prevalent in Nazi Germany. Compensation for miscarriages of justice was one aspect of the ICCPR that New Zealand said, it's not in our law and nor are we going to have it. So that was what they call a reservation. That enabled us to ratify the treaty, but just said not that bit.
So we falsely imprisoned them. We don't give them compensation. Because I think we have paid out in the past.
Yeah, depends what you mean by falsely imprisoned. If it's a miscarriage of justice situation where a person was sort of validly convicted, but some time later, let's say the David Bain case is a current example, then there can be ex gratia payments. And that's the New Zealand government's way of saying, well, we do give compensation, but we're not giving it as of right. It's not a formal entitlement, but we're not oblivious to it, and so we'll set up a process for deciding whether we will still compensate, even though we don't have to. Yeah. Some countries do it differently. They have a formal system where you've got an entitlement to a process. The New Zealand Bill of Rights Act came quite a bit later in 1990, and it was said to affirm rights in the ICCPR, and to that extent, for the first time, takes those rights and brings them into New Zealand law, just like the UK did when it brought the European Convention on Human Rights into UK law. Our Bill of Rights takes pretty much the text of the ICCPR, tweaks it a bit, paraphrases a few things, but puts it into our law. And there's still vague phrases, everyone's got the right to freedom of expression, or freedom of religion, or fair trial, or no discrimination on the grounds in the Human Rights Act. They still require what I call specification, deciding what they mean to this particular controversy or that controversy. So our rights from the ICCPR are reaffirmed in the Bill of Rights, and I asked to what end? Well, because now they're made part of the New Zealand law, they can render an act unlawful if it's inconsistent with our rights. So if the police search us unreasonably, then that's a breach of the right to be free of unreasonable searches and seizures. And we saw that happening in the Operation 8 case, where the search warrant issue went to the Supreme Court, and there was a ruling that there were unreasonable searches there, contrary to the Bill of Rights, which had the consequence that some evidence was thrown out. But the one thing our Bill of Rights can't do, whereas some Bills of Rights in other countries can do, it can't overrule an act of Parliament. So at the end of the day, Parliament says, this must happen. There can be a search in that situation, and the courts were to say, yes, but that's unreasonable. So long as the statute, Parliament clearly says it can happen, then the Bill of Rights can't stop it happening. But actually that doesn't happen very often in our legal system, because it's rare for Parliament to actually legislate completely contrary to a right or a freedom. Usually there's room to interpret what they've done in a way that protects rights. Of course, with the marriage issue, it's not in that category. So if the law says a man can marry a woman, but not a man, then that's sort of clear enough, and you can't, if you decide that the Bill of Rights requires that a man be able to marry a man or a woman, it's hard to take the words of that law and interpret them differently. And then you're told also that you can't overrule. And so we'll see how that was to play out in a moment. It was the Quilter case in 1998. And that was a case where 3 lesbian couples went to the registrar of births, deaths and marriages and asked for a marriage license, and he didn't give it to them. And of course, that enabled the argument, well, there's just been an act or an omission. Your failure to give me the marriage license or give us the marriage license is a breach of our right to be free from discrimination. Why did you not give it to us? It was because of the sex of one of us. If it had been a man standing next to Ms. Quilter, then the pair would have got the license. But because it was a woman, they didn't, and hence it was, on its face, sex discrimination. Not sexual orientation discrimination, but you can refashion the argument in another way to say it's sexual orientation discrimination too. I'll come to that maybe. And so there's your allegedly unlawful act, discrimination. But the marriage registrar says, but that's all I can do. He might have really wanted to give them that certificate. But he says the statute, the Marriage Act, under which I get my power to give out certificates, requires that one of you be a man and one of you be a woman. So your argument, Ms. Quilter, is really with Parliament, not with me. And when it's with Parliament, you've got to accept that your Bill of Rights can't trump what Parliament has said. So the case came before the courts, where it became a question of interpreting the Marriage Act. Does it or does it not require the 2 parties to a marriage to be of different sexes? And as it turns out, the Marriage Act is spectacularly ambiguous on that, because it doesn't anywhere say that one party to a marriage shall be a man and the other a woman. And I think it's hard to sort of avoid the conclusion that the only reason it doesn't say it is because it was so obvious in 1955 that nobody would have thought it necessary to say. And yet it enabled the argument that, well, if it doesn't actually say that, there's a choice then, isn't there, for a court to make. Maybe the concept of marriage has changed, and the courts can say that whereas marriage once meant between a man and a woman, now it can be between people of the same sex, and because the Marriage Act doesn't actually dictate that it be between different sex couples, is that little scope for interpretation where a court could say that, yes, even though you're of the same sex, you can still get a marriage license. Does everyone see the availability of the argument? The only sort of factor telling against that was buried back in the schedule to the Marriage Act was the list of prohibited marriages, where your consanguinity and affinity, where it said a man cannot marry his sister and a woman cannot marry her brother. And that sort of gives away the understanding that the drafters of that act had, because if they'd been thinking same-sex marriage, they would have said a man cannot marry his brother or his sister. And so that just sort of illustrated the assumption of the Marriage Act. So the case went to court saying, well, it's at least possible to interpret marriage as being between people of the same sex. And to the extent there's scope for the courts to interpret the word marriage that way, when Parliament hasn't dictated literally that one be a man and one be a woman, then the judges should do it. And just hold that thought, because the idea of judges making that step was something that was to happen a little bit later on in some other countries, but it didn't happen here. First of all, 3 judges of the 5 said that simply that the absence of the possibility of same-sex marriage is not discriminatory within the meaning of Section 19 of our Bill of Rights, which is the right against discrimination. And they said it can't be discrimination if the difference in treatment rests upon social values. And I think that was in shorthand a sort of statement of saying this is really a matter for the assessment of parliaments. It's not something that judges ought to do. We can't sort of reassess these big social questions as judges. It's not law, it's social policy, and that's for parliaments. One judge said, yes, it is discriminatory. But then he went on to say, whether the solution is same-sex marriage or civil unions, it's not for me to say. Parliament could maybe do either, but it stays the way it is discriminatory. And the final judge said, well, on the face of it, it's discriminatory, and I would need to think more about whether discrimination is beyond the face of it. It really is discrimination, but I don't need to decide, because all the judges said that whatever we think, the fact of the matter is the Marriage Act was enacted on the basis of heterosexual marriage, and to say it permits a same-sex marriage now would be tantamount to writing a new law, not interpreting the old one. And so the plaintiffs in that case lost. Meanwhile, around the world, in Massachusetts and Canada, the sort of judge-derived argument did work. That is to say, the argument in those countries was, well, marriage is a common law concept, meaning that it's something that judges have defined in the past. And so long as there's not a statute saying one person must be a man and one must be a woman, so long as the statutes just talk about marriage and talk about marriage licenses, it's leaving the question of what a marriage is to judges to define. And in Canada, they said, well, given the rights against discrimination in the Canadian Charter of Rights, it's no longer appropriate for a judge to define marriage in a way that discriminates against people by reason of their sexual orientation. And so same-sex marriage came to Canada by reason of that judicial interpretation. And so too it did in Massachusetts. And one or two other American states I'll list off a little bit later on. That led to, in the USA, the Defense of Marriage Act, in which the federal Congress enacted a law that said marriage is the union of a man and a woman, and it said that it denied federal benefits to those out in the states who had same-sex marriages. They couldn't say you're not married, because that's a matter for states to decide themselves, but the federal government could say, we federally are not going to regard you as married and give you federal benefits if it's a same-sex marriage. So that was the Defense of Marriage Act, and that's the thing that's being challenged tomorrow in the US Supreme Court. Elsewhere around the world, civil union laws became more common. The Quilter case, meanwhile, went to the Human Rights Committee. The Human Rights Committee, under the ICCPR, dismissed the case. They said New Zealand law is not inconsistent with the ICCPR, because the ICCPR has a right in it that says every person has the right to marry and to found a family. And you can see the argument there. Everyone's got a right to marry. Does it mean the right to marry anyone you like? Or does it mean, does the word marry have a sort of understanding of a man marrying a woman and a woman marrying a man? And the ICCPR committee, the Human Rights Committee, said, well, back in 1966, when this text was settled, it meant heterosexual marriage, not same-sex marriage. And therefore, what's happening in New Zealand isn't a breach of the ICCPR. And as I say here, that's an instance of what you might call originalism in the interpretation of a document. Does a document mean what its drafters intended it to mean at the time? Or when you put the word marriage into a document, might you be said to be envisaging that the concept of a marriage can sort of expand and vary from time to time? That's an interesting and quite an important question, particularly in a federal country, where you know how federal countries typically have a sort of federal government and a state government, and if the Constitution gives the power to regulate marriages to, say, the federal government, and it decides that from now on marriage will be a same-sex marriage, there's an argument that it's acting unconstitutionally, because the Constitution says you can regulate marriage, but marriage is between a man and a woman. And you can't just sort of declare something else to be a marriage and give yourself power over it, because that's sort of creating powers you didn't have. It's an interesting question about how to interpret constitutions, and we see it playing out with our Treaty of Waitangi, of course. Do you interpret the words as people understood them in 1840, or do you give it a living sort of meaning? Could it mean airwaves and water and rivers? generally speaking, I think we've liberated our treaty from originalism and just sort of forced our courts to solve modern controversies using the language of 1840. Yeah.
So they don't review these. They don't review them all the time. These documents.
They being who?
As in, say, the Treaty of Waitangi. They're trying to interpret the language of the time. They're not reviewing these treaties constantly to make sure that the language set within
No, No, because I think if we set up a process for reviewing the Treaty of Waitangi, we'd have decades of of debate on our hands, as we might have with the current constitutional review process. And certainly, if you reopened the ICCPR and some of these treaties, it would be pretty hard to get agreement on the controversial issues. So no, there's no process. Now, the recent same-sex marriage debate. I think to understand this, it helps to realise the Bill of Rights is a floor and not a ceiling. In other words, a Bill of Rights is to say, here are the rights that people must have. Nothing stops parliaments from sort of saying, well, as long as you don't infringe these, we can do other things. So, in other words, a Bill of Rights might not compel same-sex marriage, but it mightn't prevent it either. And that has been pretty much the approach that has prevailed in many of the American states, and that's what we're looking at here in New Zealand, that there's a proposal for same-sex marriage, not being compelled by any court case, and there's nothing in the Bill of Rights to stop it, unless, of course, a particular proposal offends somebody's rights. And that's what we're going to look at when we get to the question of exemptions. So that's what it becomes about, the question of exemptions. And by exemptions, I mean of marriage celebrants from being required to sodomise same-sex marriages. So that's what I want to look at now. And I want to look now, what does the international human rights dimension contribute to these sorts of debates? First of all, is it an imperative for same-sex marriage? And the answer is, well, international law is in fact not a noticeable imperative. Around the world where domestic courts or parliaments have in fact brought same-sex marriage in, then international human rights law hasn't played a significant part. And in part that's because the ICCPR is interpreted not to include same-sex marriage. And the other treaties don't speak to it, the Torture one, and the Child Convention, and so on. So I don't think you could sort of say that international human rights law is sort of taking the lead in the move to same-sex marriage where that is occurring. As to the case for exemptions, it's a bit different because to the extent that the case for exemptions is based upon freedom of religion, then you do, of course, find the phrases freedom of religion in the international documents. And so there is recourse to those phrases and what they've been interpreted to mean. So look at the North American experience. There's been a judicial granting of same-sex marriage in Canada in about 2001, in Massachusetts, in Iowa, in California. And then there's been legislative allowing of same-sex marriage. That's where the Parliament or the state legislature enacts the possibility of same-sex marriage. And that's Maine, Maryland, New York, Vermont, District of Columbia and Washington. So you can see it's sort of the far northwest, and then it's sort of basically maybe New Hampshire's there as well. I missed that out. So it's pretty much the northeast and the northwest and California. California is in a sort of state of limbo because this case being argued tomorrow, Hollingsworth and Perry comes from California, and what the issue there is that there was a court case which ordered same-sex marriage through interpretation, and then there was a citizens-initiated constitutional referendum, this is possible in Canada, but not here, called Proposition 8, which amended the California Constitution to say there shall not be same-sex marriage. And the current status of that case is that Federal Court of Appeals has invalidated Proposition 8, saying that it breaches the US Bill of Rights because it denies equality to gay people and also denies liberty to gay people to choose a marriage partner of their own sex. And that liberty argument draws upon a case from the 70s about interracial marriage. It was in Virginia, marrying somebody of a different race was once illegal, but the US Supreme Court struck that down and said that's a law you can't have consistently with the US Bill of Rights because there is a right of liberty to marry as you choose, and the state has no business restricting your marriage partners on the basis of race. So that's, if that decision of the Federal Court of Appeals is affirmed by the Supreme Court, then there'll be same-sex marriage in California. The United States in Windsor is a case about the federal law, the Defence of Marriage Act, and that's the federal Congress passing the law that says, basically it says two things. No state has to recognise the same-sex marriage of another state, and secondly, no federal benefits will go to same-sex marriages. And that case is brought by a Windsor plaintiff who was a same-sex partner. She married in Canada in 2001, but her partner died in New York, and because she wasn't, because she was a same-sex partner, the Defence of Marriage Act cut in and has an effect on the death duties, and so she suffered, and she's saying that it's an unlawful, unconstitutional invasion of my equal protection rights under the US Bill of Rights. So those two cases will be decided, argued tomorrow and the next day, and probably about June or July is when the decision would normally come out. And they will be momentous cases in American jurisprudence, rather like the abortion case back in '73, where the court gets the chance to either sort of go ahead of public opinion, or I'm not sure where public opinion is sitting in the US, but you know, it will be certainly closely watched. And if you go online, I'm sure you'll find tomorrow an account of how the argument goes. Now, the question of exemptions. Moving away from the case for same-sex marriage now to the question of if there be same-sex marriage, and how do we think about whether or not there should be exemptions? The current bill, the Wall's bill, she's up front and said, it is not my intention to force any marriage celebrant to conduct a marriage of same-sex couples against their will, against the celebrant's will. And she pointed to this, which is in the Marriage Act, always has been. A marriage license shall authorise but not oblige any marriage celebrant to solemnise the marriage to which it relates. And then, as you might have read in the papers, there was a sort of controversy about whether that was really enough to attain the stated objective of this law. Because you could look at that and you say, well, yeah, sure, if there's a marriage license, that means I don't have to form the marriage. If I'm a marriage celebrant and I turn somebody down, even before there's a marriage license, I mean, there might never be a marriage license because I might, when they ring up and say, no, sorry, I don't do same-sex marriages. There would be your act of unlawful discrimination, contrary to the Human Rights Act or the Bill of Rights. And the mere fact that this section said, well, nothing in the marriage license compels you to do it, is a bit irrelevant. There would be a marriage license. But there would still be an argument that you committed the unlawful act of refusing to carry out. So that's why there was a concern that this was not a very clear way of attaining what was the stated objective in this law. And so that's when the Law Society committee that I'm on chimed in and said, well, if that's the objective, to create an exemption in Section 29 doesn't actually work. And as when the Select Committee reported back, they agreed with that and they said it needs to be clearer. And I've got it on the next slide, what their proposal is. But I just wanted to say, look more broadly now at this idea of accommodating religious belief into law, any law, not just same-sex marriage. First thing I want to say, it's not a new idea, because if you look back in our history, then there are quite a few occasions where laws have been drafted in a way that is solicitous for religious belief. Even if you go back to the idea of swearing on the Bible, which will give true evidence, it was 100 years ago that the law introduced the idea that, well, you also affirm, goes for Quakers and people who weren't religious. So the law accommodates. And you see it with abortion law back in 73, when we put the right to an abortion into our law. There's a conscience clause in there saying no doctor or nurse has to do an abortion. And it's the second bullet point there that's significant here, that you can have a neutral law that has an indirect effect on religious belief. I mean, you can have a law that's not just aimed at harming religion, like no one shall discriminate on the grounds of sex in employment. Then you think, well, what about Catholic Church? Who has a religious belief about a male priesthood? And so you'll see that our Human Rights Act actually writes protections in that are designed to safeguard that practice. And so the point that I'm sort of making is that it's not a new thing to accommodate religious belief into our law. And as you saw in the Louisa Wall's bill, the intention was to do just that. The argument was just about the detail of whether the law succeeded. So in the submissions process about the bill, I think there were these issues. Is a religious exemption required at all? Well, nobody's really argued that it isn't. But you could. You could say, no, why should there be an exemption? Why shouldn't ministers in the church be required to perform a same-sex marriage? That would be a difficult argument to make, because compelling ministers of religion to do something that they feel violates the doctrines of the church would be a step that I would hesitate to take in our law, and might be thought to take us back into the 17th century or earlier. But as I say, it's never been on the table anyway. The question is, if there's to be an exemption, was Section 29 sufficient? And if it's not sufficient, what goes in its place? Interestingly, the Wall Bill would have allowed the exemption to all marriage celebrants, even those that had no religious reason at all. So a person who was a marriage celebrant could have just said, no, I'm not doing that marriage, because of the same-sex nature of it, without needing to sheet that home to any sort of religious belief. So the question is, should it have been that wide? The Select Committee, as it's now reported back, wants to limit the exemption to celebrants from the named denominations in the Marriage Act, which are the sort of 10 principal denominations, and also to those from religious groups, which is another category in the Marriage Act that can nominate marriage celebrants, but not to the marriage celebrant that is not affiliated to a religious group. So there would then be a category of marriage celebrants who don't get the exemption, but the religious ones would. So that's the question. Should it be allowed to none, the exemption, or to all? Does allowing religious exemptions at all demean the idea of conscientious but non-religious belief? The point I want to make here is that whenever you make an exemption for religion, it sort of begs the next question, which is, well, isn't that discriminatory against people who don't have a religious belief but would still like to engage in the same conduct, in this instance, refusing to perform a same-sex marriage? And it sort of raises the question, are religious reasons for doing or not doing something different from non-religious reasons? So that's a sort of interesting question. The next question is, how wide should any exemption be? Because a question around the world that crops up in this context is, forget the celebrants. Let's imagine that the law is not trying to force celebrants to perform marriages against their will, but it comes down to the caterers and the photographers. You rung up as a photographer and you say, sorry, I'm not going to do that wedding because it's the same sex, it's against my beliefs. The exemption proposed here will not cover photographers, caterers, and car chauffeurs and so on. And the question is, should it? And that's a difficult question. Because on the one hand, you'd think, well, there are many other photographers out there that could be asked, and why should the law force a photographer even to do something against their will? But on the other hand, the argument is, should we enshrine in our law something which enables photographers to decline something on the grounds of the sexual orientation of the would-be customer? Is that sending a message of inequality in our law? Those are the sorts of questions that are involved. So here's what has been recommended. Keep section 29, but add this to it. Without limiting subsection 1, no celebrant who is a minister recognised by a religious body in Schedule 1, and no celebrant is a person nominated to solemnise marriages by an approved organisation, is obliged to solemnise a marriage if it would contravene the religious beliefs of the religious body, or the religious beliefs or philosophical or humanitarian convictions of the approved organisation. And there are a few issues about that wording, like it seems like it's the religious beliefs of the organisation that are significant, not of the actual person. And I think that's what some of the submissions will now be about. Does international law assist with any of this? Well, the ICCPR deals only with general principles. As I say, it doesn't really assist with the case for same-sex marriage. That's being sort of dealt with by the ordinary political process. Does it assist with the case for exemptions? Well, there aren't really actually many instances of that question getting to the international tribunals, although the European Court has had the case of a Christian marriage registrar, sort of like a civil office registrar who did the in-office work, and it was about civil unions, not same-sex marriage. And she'd worked there for some years. A civil union law came in, and the office in which she worked wanted all of the registrars that did the sort of registering to become also celebrants for the in-office registry office civil unions. And for a while, she said, well, I don't do that. It's contrary to my religious beliefs. And that sort of worked okay for a while because the task was just allocated to others, sort of like my photographer example. But then there were complaints about her from other office workers saying that's demeaning to people on the grounds of sexual orientation. And I'm working here, and I feel that if this office has a program in place whereby her beliefs that the sorts of relationships that I value are not valued, and you orchestrating your affairs of your office so that she doesn't have to do those, and that demeans me. And so there was then an employment law case against her, and the contest was between her employer's duties to respect the rights of gay employees and her religious rights. She lost in the English courts. She took that case to the European Court of Human Rights, saying that in this balancing between my religious rights and the equality rights of gay couples, that the English courts got it wrong. They should have recognised that there are plenty of other marriage celebrants in the office. They could have done it, and why have they elevated these rights over my rights? And she lost that case in the European Court of Human Rights, and they said, in the European Court, they said, well, we see your point, but in this decision as to how to allocate the respective weights of these two rights, that's a matter for the local country to sort out, and it's within the range of reasonable possibilities to do it the way you did, and therefore it's not a breach of the European Convention. That's Mrs. Liddell there, and that's Mr. McFarlane, who was involved in a similar sort of case. He was a counsellor who worked for an organisation, a private organisation, and became known that he wasn't happy counselling same-sex couples, although he was involved in relationship counselling. And the same issue arose there, that while for a while it could be orchestrated such that he didn't do the same-sex couples, in the end his organisation said, well, to the extent that we facilitate that, we are sort of sanctioning the view that your refusal is based upon, and hence we are dismissing you. And he also lost his case in the European Court of Human Rights. So that's the state of the play, and I think that's conclusion. There it is. International human rights law are a promise to the world as to how a state treats those within its borders. But it's domestic law, not international law, that applies in New Zealand. Domestic law ought to give effect to the promises, and ours does in general, but our rights are expressed at a higher level of abstraction, leaving much to be resolved in particular controversies. And that's why there's not a clear answer to all these questions.
Thank you very much.